on powers of attorney. It's a very special, I think, the trope to our lecture series for GALs, because it's very important for GALs to understand what to do in the course of their mandate when they identify a power of attorney. And I'm very happy to welcome Carrie Peck.
Thank you, Howard. Appreciate it. Good afternoon, ladies and gentlemen. Welcome to the CVLS IDA Collaboration CLE Seminar. I want to first of all thank all of you for coming out, and I want to thank you at the same time for volunteering your time, your precious time, a commodity that's near and dear to all of us, to the Chicago Volunteer Legal Services Organization, whether you serve as GAL or whether you're appointed counsel in a different case or a variety of cases. It's very, very important that we attorneys continue to provide pro bono services and give back to the community. So this afternoon we're going to talk about powers of attorney. Powers of attorney, as you know, come in typically two flavors. A chocolate version is power of attorney for healthcare, and a vanilla version is power of attorney for property. And we're going to talk about the POAs in conjunction with guardianship cases. I don't like to conduct these programs in a monologue fashion. Gentlemen, do we have the ability to record questions from the floor during the presentation, or do you want me to
I'll repeat them, so yes.
Great, okay. So if you have a question, let Peter know and he'll repeat it into the microphone. As you're probably aware, we're live on the web. We're going to get questions from folks in their offices or at home, wherever they're watching. And so we need to govern our logistics accordingly. You each have a handout in front of you that you received when you arrived. We're going to open with a hypothetical that appears just past the intro page, so to speak. I'm going to read that for the folks at home watching on the internet or in their offices. Huey, Dewey, and Louie are Donald's three sons. Huey, a father of three, had always taken the initiative in caring for his 65-year-old father. He takes him to the doctor appointments, makes sure the house is tidy, there's no food in the fridge, and that all the bills are paid. So 2 years ago, Huey took Donald to a lawyer where he named Huey as agent under the powers of attorney for property and health care. 1 year ago, Donald moved in with his son Dewey because his house was too large for him. Dewey, a bachelor and a realtor, not only took care of selling his father's house, but he also took Donald to an attorney, naming himself as his father's agent under his power of attorney for property and health care. About 6 months ago, while walking to the senior center, Donald was hit by a car and sustained a traumatic brain injury. Even with the injury, Dewey rarely took his father to the countless doctor's appointments or therapy. Dewey didn't take much notice of his father's major physical and mental decline because he was spending all of his free time with his new model girlfriend. Louie, a flight attendant living two hours from his two brothers, and recently came to stay with Dewey and Donald for a long weekend when he learned of his father's brain injury. Louie wasn't close with either brother and always held a strong sense of resentment toward them. Even though Louie had never helped care for his father in the past, he decided to take Donald to a lawyer to become his guardian. Despite the fact that Louie was always traveling, he didn't want to give either of his brothers the glory of being their father's caregiver, especially after he saw that Dewey didn't concern himself at all with their father's well-being, and Huey was too busy taking care of his kids. During the guardianship case, it was discovered that both Huey and Dewey had both separately been named agent under Donald's powers of attorney for property and health care. So in the guardianship world, I call this type of a case dueling powers of attorney. Probably everybody in the room, or some of you, have been to the Howl at the Moon location where they have dueling pianos. These are dueling POAs. And it's an issue that the judge is going to have to deal with right away. because let's not lose sight of the fact that a valid power of attorney is a defense to a guardianship case. So if I file a guardianship case against Howard, and I assert that he needs a guardian, and Peter has a valid POA for healthcare and valid POA for property, he has a viable defense to that cause of action. He can come in and should come in and file a motion to dismiss the guardianship. So if you're appointed GAL and you become aware that there are powers of attorney allegedly executed while competent by the alleged disabled person, that's something you're going to want to consider right off the bat. So as we analyze the guardianship cases that we are all involved in, it's really a two-pronged inquiry. The first prong is, does Howard need a guardian? Is he disabled? And the second prong, of course, is, if so, who should it be? So we have disability as issue 1 and choice of guardian as issue number 2. All of these integrated with, is there a power of attorney? Has the alleged disabled person expressed a preference relative to the choice of guardian? As we know, in the durable power of attorney forms, individuals are named, when they're named agent, they're typically also named as a potential future guardian. So in our dueling powers of attorney scenario, we want to know the existence of a power of attorney for health care, the existence of a power of attorney for property. We also want to know and analyze whether they're valid, and their validity, of course, depends upon when they were executed, what the capacity of the principal, your alleged disabled person, was at the time of execution. So did Howard have the capacity to sign a power of attorney for health care? Did he have the capacity to sign a power of attorney for property? And even if he had capacity, okay, did Eileen unduly influence him to name her agent under one or both of those documents? So in conjunction with the analysis of a guardianship case, when you're GAL and you find out there's POAs, you really need to stop and start to analyze the case along the lines of the context that I've just suggested. So we know collectively why guardianship is necessary. More often than not, we see one of the variety of reasons that are on the next slide. Perhaps the power of attorney was abused, and somebody has filed under the Probate Act to seek to remove an agent for abuse of that power of attorney. Maybe they've used it to pay themselves extraordinary amounts of money, or they've taken money from an alleged disabled person's bank account, they've sold a house inappropriately, a variety of abuses that we could easily name. Or maybe they've unduly influenced the individual in conjunction with the making of decisions, not just a decision to sign, but a decision perhaps to sell their home and give all the proceeds to, in our hypothetical, one of the three boys and not all of the three boys. Or there's a different kind of breach of fiduciary duty, which may rise to the level of breaching the duties of loyalty and honesty and integrity, again, kind of along the lines of POA abuse. Likewise, financial exploitation takes on a variety of forms. It could take on just outright theft. It could take on use and occupancy of a home with not paying rent. It can take on, just a myriad of different directions. Is a guardian necessary because purportedly the agent is financially exploiting someone? Or, as we know, financial exploitation comes in completely unrelated to POA formats. A caregiver is financially exploiting an individual. A child is exploiting his parent or his grandparent. As you know, and unfortunately we see every day, the first line abusers in financial exploitation are loving family members who believe that they're entitled to the money right from the get-go. And of course, the second line abusers are caretakers, more often than not, those that live in 24/7 and isolate an older adult. So as GAL, when you're faced with the variety of these types of circumstances, you're going to want to know, again, is there a POA? So in Illinois, we traditionally assert that there are two levels of capacity, two general levels of legal capacity: testamentary capacity and contractual capacity. Wills, as you know, require testamentary capacity, inter vivos trusts, powers of attorney, and so forth. Now, it's quite interesting. This seems to be increasingly more of an academic distinction than what I would suggest a realistic distinction. There seems to be a merging of testamentary capacity and contractual capacity. There certainly is some case law that would indicate that if a will is signed at the same time a trust is signed or a deed is signed, that the capacity test should be testamentary capacity. So testamentary capacity, as you know, and I continue, despite the fact that I've been involved in the practice of law in this arena for over 30 years, I continue to be horrified that testamentary capacity is basically the lowest level of capacity that we lawyers can assert or talk about. Okay? Our jury instructions would say, in order to sign a will, someone needs to know it's a will. They need to know the nature and extent of their bounty, their property. They need to know the nature, who's their family. And last, of course, they need to know that we need to know that that individual, the testator, had the capacity to form a plan in their mind. Okay? Probably the toughest of those four elements. So contractual capacity, I suggest, is being phased out a little bit. I was involved in a case very, very recently, and Judge Quinn of the probate court indicated that she was going to go out of Illinois for purposes of locating contractual capacity authority, that she didn't find any contractual capacity authority that was of great value in determining the viability of powers of attorney. So it's a distinction. The question is, and I pose it really rhetorically, is it a distinction without a difference? Okay? In many years ago, Judge Dowdle, who sat in a probate court, ruled that you needed a higher level of capacity, and contractual is that higher level, to revoke a power of attorney for property. And as we all know, there is what I think continues to be, some would argue, not aboriginal, I would say an aboriginal provision in the law, that you can revoke a power of attorney for health care regardless of capacity. So we see a lot of circumstances in which individuals suddenly stricken with mental illness or a bout of mania during a bipolar episode revoke their POAs for health care without capacity. So you need to be aware of that as a GAL. Your alleged disabled person could say, I don't trust my daughter, I don't want her to be my agent, even though that's an old POA for health care. So it's a shifting circumstance. It's a very fluid situation. Testamentary capacity, we kind of talked about it a little bit already. Most people describe it as sound mind and memory. I can tell you that I had a quite interesting conversation with a physician quite recently in one of my cases, and I asked him to write a report indicating that the testator had testamentary capacity, was of sound mind and memory. And the doctor said to me, Mr. Peck, I went to medical school. I don't know what testamentary capacity means. Okay? I don't even really know what sound mind and memory means. He said, if you're asking me to write about, this particular individual, I'm going to write about it in the medical terms that I studied when I went to medical school. So it's kind of interesting. It's really a kind of vivid example of the clash, so to speak, certainly between the linguistics of the legal system and the medical system. We want them to interlock very succinctly. We want the doctor to write in our CCP 211s If the individual is totally incapable of making personal and financial decisions, that's what the statute requires. The statute really does require testamentary capacity, kind of interpreted by case law as to sound mind and memory. But more and more, I think the medical community is reticent to use the language that we lawyers cite to them in conjunction with capacity issues. Anybody else experienced such an interaction? Okay. So on the right side of the slide, it's probably your left side of the slide, we went through the elements a few minutes ago, knowing that you're making a will, natural object of your bounty, character and extent of property, and ability to form a plan. Character and extent of property is kind of an interesting one because if I know that my broker is managing my money at the private bank, they're managing my investments, do I really have to know how much I have? Okay? And you start kind of slicing the onion in terms of all of these elements. And if I'm able to tell you that, Howard Burke manages my money through the IDA or manages my money through the private bank, do I really have to tell you that I have $500,000 in stock? Am I compelled to understand that? Is that part of the analysis of comprehending the nature and the character of the individual's property? So again, contractual capacity, it's required for inter vivos trusts, but if I sign a revocable living trust at the same time I sign my pour-over will, and certainly the state-of-the-art estate planning today is those two documents, pour-over will, revocable living trust, our case law would seem to indicate that we apply testamentary capacity, not a contractual capacity. And it's defined as the ability to comprehend and understand the terms and effect of the contract. At best, I would say, an amorphous type of scenario. Assessing disability in the context of a guardianship case. Everybody in this room is I believe, either volunteered to serve or may have already acted as a guardian ad litem in a guardianship case. So you know that under the statute, there are a variety of reasons for a guardianship case to be filed. Certainly in the older adult circumstances, we see most of them relate to cognitive impairments, very frequently Alzheimer's disease or vascular dementia, some type of cognitive impairment. We also see I'd say a growing number of young adults that suffer from developmental disabilities as the facilities that they're living in or their parents are told that they need to get guardianship over their child who turns 18. That's pretty clear in the statute. I haven't seen too many cases or any that involve idleness or debauchery, despite the fact that it's contained in the statute. I have seen them for gambling and, of course, intoxicants or drugs. And I think statistically we would probably agree that the vast majority are older adult cognitive impairment cases, and certainly an increasing number of people that suffer injuries in med mal cases and things of that nature. So we talked about Donald having dueling POAs. We talked about potential remedies. One of those remedies is seeking removal of the agent if the agent is not acting in the best interest of the principal. And this could be a trial in and of itself. So we're talking about a potential petition seeking to remove the agent for not acting in the best interest of the principal. We're talking about using a motion to defeat a guardianship in conjunction with the valid POA. So again, the focus of our discussions today are POAs. Is it valid? Was it unduly the result of undue influence? And is the agent acting in the best interest of Donald, our hypothetical alleged disabled person? As we determine who should serve as guardian, we find if a guardian is necessary, in many of the cases that you're involved in, and certainly I'm involved in, there's more than one loving family member who wishes to act as guardian. Well, most of these family members believe that if they act as mom or dad's guardian, they will have a leg up in inheriting mom or dad's money over their other siblings. We lawyers know that that's not true, but it doesn't matter how many times you discuss that concept. Folks want to be guardian, sometimes for reasons other than money, but more often than not for reasons to the control of money. Clients rarely come in and say, I'm tremendously concerned about mom's health care, I want to be her guardian. Excuse me, on reverse. Clients always come in and say they're concerned about mom's health care, they want to be her guardian. And then, of course, when you, again, peel the onion back, you find that mom's got a few dollars, and that individual doesn't want their siblings to be involved in the management of mom's money. So the court needs to determine who should act as guardian. Of course, you're going to involve the doctor that wrote the CCP 211, your alleged disabled person as guardian ad litem, and you may be appointed as defense counsel. Okay, it may be necessary for you to get an independent medical examination to determine whether you agree with the assessment provided in the petitioner's CCP 211. I would encourage you to do that, particularly if you're appointed defense counsel. If you're appointed defense counsel, I would suggest that you actually have an obligation to find out if your client could pass a mental status exam, so to speak, by another physician. Certainly third-party testimony is going to be involved in who should serve as guardian, and you're going to, a lot of these cases, particularly these family battle cases, are airing the family dirty laundry. It's an unfortunate set of circumstances. My sister was mean to me in high school and didn't let me use her dress to go to the prom. We're hearing all those kinds of things just come rushing out as to why I'm a better guardian than the person across the room. Additional factors in determining who should be guardian, the recommendations of people with family ties, the relationship between the disabled person and the party being considered for appointment. So in our hypothetical, obviously we have nothing good to say about the son who was more interested in his new girlfriend than in taking dad to the doctor if he's nominated to be guardian. The conduct by the disabled person prior to being adjudicated, which manifests trust or confidence in the proposed guardian, certainly an expression of trust and the creation of a fiduciary relationship in a power of attorney, is relevant if that individual had the capacity and, of course, wasn't unduly influenced. So if I express my trust and confidence in Peter and prior to the guardianship, and I wanted him to manage my property and healthcare affairs in advance, no doubt we already know that the durable power of attorney says if I need a guardian, I want Peter. That's a clear expression of my desire, presumably made when I was competent. In addition to prior actions by the proposed guardian which indicate a concern for the well-being of the disabled person. The reverse is quite true, okay? And the reverse is also an integral part of the evidence in these cases. The reverse is one of the agents under POA took money, okay? That agent took money to go to Disneyland, to go on a vacation, didn't take the alleged disabled person with, but just took mom or dad's money. So clearly that type of behavior is going to cut the credibility of that proposed guardian in conjunction with this guardianship. But again, we're focusing today on POAs. So we want to know, if I walk in the courtroom with dueling POAs, what did those agents do good for Donald or bad to Donald? Okay, and that's the substance and kind of the crux of the evidence that we're looking for. So we want to know the ability of the proposed guardian to manage the disabled person's estate, and we want to use, again, our prior interaction, our prior interactions with that individual if they were agent. And Dad, in our hypothetical, Donald, let's assume Donald had $1 million and he was managing it by himself or with his sons. How did the sons that had POAs for property do in conjunction with that management? Did they do a good job? Did they do a bad job? The extent to which the proposed guardian, and again the agent, is committed to discharging the responsibilities which may conflict with his or her duties as guardian. Are they involved in investments together? Okay, those are all kind of tricky scenarios when Dad is involved in investments or in business with one of the kids who may hold an agency under power of attorney for property. Is that agent and proposed guardian acting in the best interest of Dad or the best interest of himself or herself in conjunction with the business? Same thing as simple as owning a home together. Okay? Do they own it in joint tenancy? Do they own it 50-50? How do they own it? And who's acting for the best interest of whom? Trial court must consider the preference of your client, or if you're court-appointed counsel, or the alleged disabled person if you're guardian, if GAL. It doesn't mean that the court must comply or follow that preference. That's very, very important. Okay? A lot of people believe that even if named under POA to act as guardian, that's going to be outcome determinative. I would suggest to you that that is a strong expression of preference, but it is not going to hold the court bound to a decision in advance, yes, the agent is named. An agent's going to have to justify the appointment. Certainly the trend in guardianship cases today, certainly family disputes, is the use of third parties, banks, perhaps care managers, some of the non-for-profit guardianship agencies, the county public guardian, the office of the state guardian, rather than the initial co-petitioners, particularly if they are siblings and they can't get along for the benefit of the alleged disabled person. Let's move on to another hypothetical. How are we doing time-wise, guys?
Plenty of time.
Great. So Bob, a 70-year-old widowed retiree, lives in a large condo in Lakeshore Drive. Bob goes to church every Sunday, as well as the senior center twice a week to play chess. He has only one child, Mary, who lives in Florida and visits on major holidays. Lately, Bob has become increasingly forgetful, confused, disoriented, and is hospitalized after slipping on a patch of ice, injuring his hip. While in the hospital, he was diagnosed with dementia. He refuses to move out of his condo, so he hires a caregiver to help him with his daily activities, such as laundry, cooking, and making sure he's properly dressed, since he occasionally forgets to change his clothes. Bob is incredibly lonely following his injury and diagnosis. He finds consolation and companionship with his young caregiver, Stacy. Stacy's a very attractive divorcee with a child. Stacy doted on Bob from the start. In addition to her duties as his caregiver, she started to pay his bills, accompany him to church, and go shopping with him. It wasn't long until their relationship took a romantic turn. Stacy and her son immediately moved into Bob's opulent condo. Shortly thereafter, the two made travel plans, and Stacy suggested that Bob buy a new car, preferably a luxury SUV, so that they would have enough room for all of their things. Stacy took Bob to the Lexus dealership. Every caregiver needs a Lexus SUV, where he bought a 2015 Lexus SUV, wrote a check for half of it, and financed the rest. She suggested that he put her name on the title as well, since she would be able to drive the SUV during the trip, and of course Bob agreed. Now that Stacy and her son were living with him, she suggested Bob should get rid of any of those other nosy caregivers and housekeepers because she would be the only caregiver he would need. Stacy then also suggested that Bob add her name to his bank accounts so that she could do the grocery shopping and take care of the household things. She also suggested that they meet with his stockbroker to make sure she could use those funds to take care of him. In addition, she mentioned that he should call his attorney to discuss revising his will so that she would be taken care of. Bob said, anything for you, and gave her the numbers to call and make the appointment. So this is kind of a hybrid hypothetical of circumstances that perhaps you've been involved in, and certainly I've been involved in. We tried a case late last year in which the caregiver was put into the home during husband and wife's illnesses. Wife passed away, and the caregiver remained, and the caregiver ultimately ended up with a brand spanking new BMW SUV. When we tried the case, some of the interesting questions were, well, isn't it true that the alleged disabled person has mobility issues and can barely walk? And of course the answer was everybody agreed. And then the interesting question was, well, how would the alleged disabled person step up into an SUV to go to the doctor, which her testimony, the caregiver, was he bought her the car so she could drive him to the doctor. Of course, her name was the only one on the title. So these financial exploitation cases are becoming, I think, rampant. I think we're seeing a tip of the iceberg. Elder abuse is really, really on the rise. I think that powers of attorney for property today are a substitute for guns that people used to use to rob banks. Today you need a power of attorney for health care. You go in, and if you're properly dressed and probably can articulate what you want in a unthreatening manner, the agent is going to walk out with a pocket full of money. That's just facts and reality. So if you're counseling your clients in conjunction with the preparation of powers of attorney documents, and I think most of you are, choose the agent wisely. And those agents are now coming back in circumstances where there's a move to hold lawyers accountable for the improper conduct of the agent. Can't say that you need to do a background check. Can't say you need to do, require the agent to post bonds. Those are obviously things that we're not going to do. But when you meet with your clients, in your practice, you need to at least put in your file that you've asked some due diligence questions regarding the selection of these agents, okay? Because I'm involved in a case that seems to be now resolved in which the push was to come back at another law firm that wrote the agency, and the agent exploited the money. There's no question they wanted to hold the law firm accountable. So think about that in conjunction with POA work. So let's go back to Bob. Meanwhile, Bob's daughter Mary began to get concerned. It was increasingly difficult to reach her father. He'd always been a very cautious decision maker, and when Mary learned that he moved a woman into his home after only 6 weeks, she became very worried. Mary, however, was afraid to say anything because she knew how lonely her father was, and she felt that maybe this is what he really wanted. While in town for Thanksgiving, Mary went to an attorney to see what she could do. She discovered her father's POA a few years back, and she was named her father's POA, Her lawyer discovers Bob had not only recently redrafted his will, replacing her with Stacy as beneficiary, and named Stacy as the new POA. So, of course, where do we go in the context of you getting appointed GAL? You're likely to get appointed as GAL in a financial exploitation case, much like the one that we've just described. You're going to get very short notice in conjunction with your appointment. You're going to be asked to go out and come back in, 2 to 3 days on a temporary guardianship case, and you're going to pretty much have to set aside, your schedule for a little bit of time to go out and investigate whether or not there's been exploitation. And particularly your job, of course, is to go out and Mirandize under the probate rules the alleged disabled person. I'm sorry, I didn't see it. Thank you. Really? So the and you know already what rights you have to give to the alleged disabled person. You have the right to consent, you have the right to oppose, you have the right to a jury trial if you want. Not very many people ever ask for one. You have the right to a lawyer, you have the right to a new medical exam, and all of these and sundry, but very, very important rights. As guardian ad litem, you are taking on a role of basically making sure that if a guardian is necessary in this case, that this individual is, totally incapable of making personal and financial decisions, perhaps a limited guardian circumstance, less, in which the individual is going to be found to and be ordered to basically give up many of their civil rights. Okay, many of the most important rights that we individuals cherish. The right to contract with third parties, the right to vote, the right to drive a car. So I think that when you get involved in a guardianship case, it's almost like getting involved in a criminal case. Certainly in a criminal case, when somebody's locked up, their rights are taken away for violations of the law. But in a civil setting, in a guardianship case, we're taking away many of the leading important civil rights of an individual in a guardianship case, and certainly many of the older adults would equate to being put into a nursing home the same as going to jail. Okay? They're no longer able to get out into the community. They're no longer able to conduct their lives the way they want. So as guardian ad litem, you've got an important duty to make sure that this individual is accorded all the appropriate due process that they're entitled to. And as you know, in Cook County, our judges collectively, and I think it's a wonderful thing, take quite seriously when an individual, even if demented, says, I don't want a guardian, I can do it myself, I want to make my own decisions. Needless to say, you may find yourself at that point then in a contested guardianship, but I think that you would also, at the other end of it, conclude that it was good experience, even as CVLS GAL. So I've got some case law sites up here in conjunction with the necessity of temporary guardians, and I'm just going to quote it for the folks at home again. Because temporary guardianship petitions are granted in emergency situations, it is important both to clearly identify the cause of the emergency and to detail how the current situation jeopardizes the alleged disabled person's financial or personal well-being. Courts do not require the same notice required under the Probate Act, Sections 11A10, since that would undermine the clear purpose of the provisions regarding temporary guardians, which is the need to attend to the immediate needs of the alleged disabled person. And again, in these type of financial exploitation cases, step one, of course, is the petitioner is going to have to present you with a CCP 211 that indicates that this alleged disabled person doesn't have the capacity to make the decisions that are in question. You no doubt have probably already crossed paths with a case or will soon in which an alleged disabled person really is not disabled, they are just making bad decisions. So the reality here is competent people can make bad decisions. I was brought into a case to defend a gentleman in a guardianship case because his family did not like the family money being spent on hookers. And they sought to have him adjudicated disabled, and we tried the case. And at the end of the case, the The female probate judge on the 18th floor looked at everybody and said, it's not the lifestyle that the rest of us would adopt. It may be his lifestyle, but I find him to be competent, and he can make this type of decision, which purportedly is a bad decision, but he's capable of making bad decisions. So when you're court-appointed guardian ad litem, that's another thing you need to assess. You know, is my alleged disabled person, you know, really disabled? We talked about, everybody I think knows we need to get the CCP 211 report. Anecdotally, do your best, although you're rarely involved in getting it, to see if it's readable. If it's not readable and you can't read it, then you probably want to reach out to the doctor and find out, you know, what it says. We all been involved in cases in which the court can't read the report, and it brings everything to a grinding halt. So it's a practical tip. The law requires that a plenary and a temporary petition be filed simultaneously. Certainly if a temporary petition is filed, you're going to go out as GAL on fairly short notice. If it's a plenary, you're going to have sufficient time. After the temp is filed, I think there are no circumstances in which I see the court waiving a GAL, even if it's a developmentally delayed adult or young adult. If a temp is filed, the court wants a GAL to get out there. Certainly temp petitions are filed, as you know, for surgical procedures, invasive surgical procedures particularly, and you're going to go out to the hospital or the nursing home facility and find out why surgery should or should not be approved. Role of the guardian ad litem. You're the eyes and ears of the court. Typically an attorney, interestingly enough, the statute doesn't require that an attorney be appointed. In Cook County, we have nobody but attorneys appointed. Yes, sir.
Not true. I'm not an attorney on that, and I have served on 40 GAL cases.
And corrected. I'm surprised. Congratulations. What's your background?
It is law, but I've never practiced anywhere, and certainly not in Illinois.
Okay, terrific. So the court is going to appoint a GAL to determine if, particularly in a temporary guardianship petition, if the relief sought is appropriate and necessary under the reasonable circumstances. And as you know, if you've been involved in temp cases, the orders for temp are going to be very, very narrow. You know, someone's authorized to take a deposit out of a bank account, place the alleged disabled person in a facility, or take steps to authorize granting informed consent to a medical procedure. Primarily, those are the two areas. And again, I think it's important that you as GAL understand the court's relying on you to make sure that the order is as narrow as meets the needs of the alleged disabled person and doesn't give that temporary guardian power to go well beyond the temp orders. Peter?
So I've got a question. When you've got these dueling powers of attorney, maybe some financial exploitation, but certainly some disagreement in what's going on with the principal or the alleged disabled person, and you've got a need for a temp guardian, you also probably then have a need for the court to suspend the authority under powers of attorney. And can you talk maybe a little bit about that, and if there's a need for supplemental pleadings to be presented to kind of do that, or if that can be done in a temp petition?
Okay, great question. I think that in most circumstances, if there are dueling powers of attorney or even one set, and you need to try and get that agent out, you would want to file a petition to suspend and or a petition to contest the validity with alternatively pleading the immediate suspension. So conceptually, the idea is that you're going to, at a temp proceeding, you're going to remove, at least on a temporary basis, the agent under one or both types of POAs, And you may wish to raise at that point for a future hearing date the validity of that POA. I would think you'd want to do those two simultaneously. Yes, I would encourage you to file a supplemental pleading. There has been many cases in which the court kind of summarily suspends those powers of attorney, and I think the judges on the 18th floor are less likely to do that now. It's not as quote unquote custom and practice as much as it used to be. So I think if you're going to ask that a agent be temporarily removed, that you're going to need a verified petition indicating why that should happen and why it's in the best interest of the alleged disabled person during a temporary guardianship proceeding. The GAL report, I think probably everybody in the room here has written a GAL report, but don't forget that basically you're duty bound and ethically bound, thank you, to basically as best as you can verbatim state your observations, and those observations may be of the house you're going to visit. It may be of the individual you're going to visit. How are they attired? Were they properly attired? Were their clothes clean? Was the house a mess? Was there, cat feces everywhere? What was going on in this home when you went out to the house to see the alleged disabled person? And the term home can likewise be interchangeable for a nursing home or for a hospital. When you got to that nursing home, were you given access to the patient? Were you allowed to review the medical records of the patient? What did the alleged disabled person's medical records indicate? What's the diagnosis? What's the prognosis? How long have they been in the facility? What's the likelihood that they're going home? What's the likelihood that they're going to be placed in another facility? And in my opinion, their medications are very, very important, particularly if they're on any psychotropic medications. Are they being given depression medication? Are they being given medication for agitation? Are they on Haldol? Are they on Namenda for Alzheimer's disease, Aricept, Alzheimer's disease? Certainly medications that would indicate a cognitive impairment exists and or a psychiatric condition exists in which lithium is used in a bipolar scenario, or Respetal, a variety of different psychotropic medications. It's very, very important that you report to the court on the use of psychotropic medications and the use of Alzheimer's disease medications. This clearly indicates that we've got an individual who's got some mental health related problems. Equally as important, if the individual is on a G-tube, gastrostomy tube, or an NG tube, nasal gastric tube, how are they being fed? What are they? What are the circumstances? Does their food need to be pureed? Do they have swallowing issues? Okay, certainly many patients suffering from Alzheimer's disease in the nearing the end of their lifespan are going to develop swallowing problems, which lead to aspiration pneumonia, which may likely kill them. So you want to make sure that again, as the eyes and ears of the court, you're there to make sure the court is more than adequately informed. You're certainly there to protect the rights of the alleged disabled person, but both of those roles are critically important, and I think you need to make sure that you get access to the information you need. If you go to somebody's house, you generally are not going to find medical records. If they have a 24/7 caregiver, and it's agency supervised, you might find on-site medical records and daily medical notes provided by the caregiver. So I would encourage you to look for that. And likewise, if you go to somebody's home, and I find a caregiver, even if it's not an agency caregiver, I say, bring out all the medications, put them on the kitchen table, we're going to go through them, and I want to get the names of each one of them. And if you are familiar with them, great, but you should be able to tell the court that, the alleged disabled person is taking a particular medication which is prescribed for high blood pressure, prescribed for, cholesterol, something of that nature, again, informing the court as to what needs to be done. Role of GAL in some of these exigent invasive surgery cases. I had the pleasure of being appointed one morning when Judge Harrison called and said, Kerry, what's your day look like? And I knew I was in deep trouble right from the get-go. She asked me to go out and be back by 4 o'clock to determine whether or not an individual should be removed from life support. This was in the days of, let's pull the plug type cases. Today we mostly use POA agents or guardians to do that. Likewise, I got a similar call to go out and come back promptly and report on whether I recommended a neurosurgery on an individual. That's certainly a viable case today because we don't have, we might have an agent, we might have a temp guardian. Those were filed in temp guardian cases. So you need to go out and get as much information in those heavy, like a neurosurgery case. You're going to want to meet with the doctors. I just called the hospital and said, the doctors have to come to the hospital now. We need to find out the viability of this lady's future. You occasionally in the guardian ad litem role are going to find out something that most people didn't know. Okay? Maybe the alleged disabled person has 2 wives. Maybe the alleged disabled person has illegitimate children. Those are very, very, very important factors in consideration in your role as GAL. So, of course, in most circumstances, we file for guardianship because there is no advance directive, there is no power of attorney for health care, there is no power of attorney for property. I've cited the McPeak case, the far end, to simply establish certain disabilities is alone insufficient to support the determination of incompetency. The evidence must also show the person's incapacity of managing one's person and estate. I've been GAL in a couple cases, and the only method of communication with the alleged disabled person was a blink of the eye. Okay? Got to set up kind of a method of communicating. 2 blinks is no, 1 blink is yes. Okay? Arguably, that individual has mental capacity. Was involved in a case in which we had an individual which today is commonly referred to as locked-in syndrome. Mentally they're fine, physically they are totally unable to manage their affairs. So the question, of course, is that person fall within the category of our statutory definition of disability? In all of those cases, the court concluded yes. I'd say that guardianship really is the default estate plan for disability purposes in Illinois. Disability affecting cognition. Can the person make decisions for themselves? If there is no effective planning for disability, does the person have a plan? Is the plan appropriate? Are the agents willing to act? And we talked about guardianship being a very effective tool to combat exploitation. Removal of agent under improper financial transactions. We talked a bit earlier. Changing the beneficiaries of a trust, life insurance, commingling money, transferring funds to benefit the agent. a trustee or agent loaning money to himself or herself, certainly grounds for removal. Are there questions that we can talk about? Yes?
I'm just wondering if the guardianship court is saying it.
The question was, are these cases sometimes brought in chancery if there's a...
I have not, Eileen, been involved in a case that there's been a ruling adjudicated or not a ruling. You've given us both scenarios. If there's a ruling, I've not seen it go to chancery. I have seen cases in which people file in chancery, but it more often than not has involved trustee scenarios, kind of standalone revocable living trustee battles. Siblings that can't agree on how the money should be managed, where mom should live, all the issues that come up in guardianship case, but they come up in the context of an umbrella of a revocable living trust rather than a guardianship case. Because the Chancery Division, as you know, has jurisdiction over trust matters unless it's during a probate of a decedent's estate. So that's been my experience. Howard?
In the normal course of your practice, when you determine or your client determines that a prospective agent is inappropriate, is deemed inappropriate, and then practically speaking, that situation, there are no family members or friends that are appropriate to act, do you have any resources you ever referred to?
You know, it's a great question, and I don't have a wonderful idea. Some banks are willing to act, and some guardianship agencies are willing to act, but it's a problem. I mean, there's no good answer to that kind of scenario that I'm aware of. But I'm open. Does anybody else in the room have an idea for someone who doesn't have family who's looking for an agent, particularly under power of attorney for property or for health, other than the two suggestions that I've made?
Other jurisdictions, people hire case managers.
Right.
I don't know, I know, for example, that in Washington DC, an association for case managers. I don't know if Illinois has, they're also, I guess there's some kind of certification.
Yeah, we certainly have, as you know, geriatric care managers. They have a trade association. I don't know if that's exactly what you're referring to, but geriatric care managers, I think, would be a good option as well. And some of them do that in the context of, case management. So I think that's a decent option. I appreciate your suggestion. Yes, sir, in the back.
In the caregiver exploitation kind of situation, is there a mechanism where the individual we're seeking to protect can preserve a power of attorney made in a period of high competency? Is there some mechanism to prevent the simple revocation and substitution?
So the question is there a mechanism to safeguard a valid POA when there's an exploiting caregiver?
I think probably the best method of preserving that is to make sure that an original of those documents is kept by a third party, perhaps their counsel, and if and when an attack is made on those documents or a subsequent document is executed in favor of a caregiver, then you have somebody who can come forward and say, the alleged disabled person did this 5 years ago when they were competent and not subject to undue influence. But these caregiver scenarios, they're very, very, very problematic because we see scenarios in which, I coined a phrase at the courthouse. I call some of these caregiver scenarios sex for signature cases because that's just flat out what they are. And And there's no way to monitor what's happening when a 24/7 caregiver, woman lives with an older adult. And regrettably, we see kind of a consistent pattern in terms of obviously the age difference and so forth. But I still believe we only see the tip of the iceberg. I've been involved in cases in which the money is gone instantly, and the caregiver's on the next flight back to, unfortunately, usually Eastern Europe. Yes. Hi.
Going to Vita's questions, let's say you have a power of attorney for property and no guardianship. Would the new elder court be an appropriate forum to file a petition to remove that agent so you can have, I don't know, something from court saying that you are now the
Question is proper venue for a successor agent to establish their role as agent.
Well, I think you're kind of talking about a hybrid case, okay? And the hybrid case is a little bit difficult. The elder law court has jurisdiction under the new rule to deal with power of attorney abuse scenarios. And so you've made a good point. The problem is, how do you resolve a removal of that agent without an appointment of, you're suggesting, a successor guardian, excuse me, successor agent? In most exploitation cases, I would argue that the appointment of a successor agent doesn't do the trick. It's not going to stop the exploitation. If I get a court order appointing a temporary guardian, in which that temporary guardian is empowered to call the private bank and every other bank in town and say, don't let them take Kerry Peck's money, okay? Freeze the money. That's a wonderful solution. If someone is appointed successor agent and they call the bank and say, hi, I'm Kerry Peck's successor agent, freeze his assets, most banks are going to go, what are you talking about? Okay? So, because as we know in the financial services world, banks, brokers rarely are going to engage in that type of freeze conduct without a court order that gives them some protection at a later date. And I can assure you their backroom legal department is not going to authorize a temporary, or excuse me, a successor guardian. So you raise a good question.
What if the court order just removed the agent? So the successor could go into the bank with the order removing the agent.
I think that's fine. I mean, if it works.
Yeah, I don't know if it
The
works.
question is if it works. And then you always run the risk that that power of attorney is going to be revoked. Okay? The reason I particularly like temporary guardianships in financial exploitation cases is it's not going to be revoked. It's not a solution in which someone else has the ability to persuade the alleged disabled person or the principal in your agency to change it. You may never know if someone pulls your successor agency title away if you've got third parties that are acting inappropriately. And that's the problem. So I'm getting the hook. Howard tells me we're out of time. I'm happy to stick around and answer some questions or engage in further discussion. Thank you very much for coming out, and have a great day.